seated, please. I want to apologize. The delay was a little bit longer than I anticipated, and that's my fault. Next case is Child Time Child Care versus Colony Insurance. Mr. Brock.
Good afternoon. May it please the Court. My name is Lindsey Brock. I represent Child Time Child Care, Inc. May I reserve 3 minutes for rebuttal. Child Time is here seeking reversal of a summary judgment entered against it in favor of Colony Insurance. Briefly, the facts are that Steamaway, which is a cleaning company and the insured of Colony, agreed to clean the floors of Child Time Child Care's facility. To save time and to clean all the floors at once, they moved all the books, tables, chairs, desks, bookcases, everything outside. During that time, rain came, everything was damaged.
Let me ask you this question, and I'm going to be asking some of Ms. Klein, I'm sure, also, but this exclusion is something that we obviously need to understand. I don't mean to cut you off, but all counsel, we're generally familiar with the facts. The problem is if we're not familiar with the facts, you got almost an insurmountable problem there at the podium. But we are in this case, I think. If they had come into this business at night, which I guess is when they were doing it, night or weekend or something, and gone in behind them and locked the doors for security and turned on all their equipment, and one of their floor buffers had just gone crazy and wrecked a bunch of furniture in that situation, would the exclusion apply there?
If it damaged the floor,
yes. Well, I was thinking of an item of personal property, but if it damaged the floor.
If it damaged the other items, no, Your Honor.
Okay.
And the reason it would not is basically if you look at the Phoenix case, which was cited by the Colony Insurance. In that case, the work that was being done was a crane was being used to lower a reactor head into a water tank. It was going to sit on a pedestal. Things went haywire, as you were talking. It busted up. And the claim was made. The court there said, just as it relates to the reactor head, the exclusion prevents recovery under the policy. However, at the end of that decision, the court made a specific determination and said, our decision only relates to the reactor head. It does not relate to the other real estate.
Clearly there was no physical control over anything but the reactor head in that case. Wasn't that true?
Your Honor, the work that was being done was related to the reactor head. The physical control was on the reactor head by means of the crane. The reactor head is what went in and damaged other items. So in the process of doing their work, they damaged the work, the reactor head, and the other items.
The issue was the other property in the care, custody, and control. And so the physical control issue dealt with the exclusion. So the other property, there was no fact from which someone could conclude that they had control over the property damaged by the head. Is that correct?
That is correct in that they said that the only item that they had actual control over was the reactor head. This other property was damaged in the process of doing the work.
Does it make any difference that in the Phoenix case you had an exclusionary clause that used the term physical control? The term physical is not in the exclusionary clause in the insurance policy here. And the court in Phoenix pointed out that physical control implies control over a material object as distinguished from control of an intellectual nature over a person, etc. I mean, are the terms, when you talk about possession, physical control, etc., does it really make any difference?
Yes, Your Honor, it makes a difference, and it is one of the reasons why the Phoenix case is not directly on point and should not be relied upon, because I believe it's on page 3 of our initial brief, we quote the specific exclusion that says personal property in the care, custody, and control. And, Your Honors, there is a factual dispute here with regards to the necessity of moving the furniture. The trial court erroneously inferred, and I believe it's on page 17 in the hearing transcript, that it was essential to effect the work to move the furniture outside.
Well, what facts in the record support a finding that it wasn't necessary to move the furniture somewhere, whether outside or someplace else within the building?
Your Honor, the facts that relate to that are, number one, if there is no furniture, then you don't have to move it to clean floors. The job, the work, was to clean floors. The furniture was incidental to the job. It's no different than if a door is closed and I have to clean the floors in that room. I have to move that door open to go in and do my work. If there happens to be a chair there on the floor, then I need to either work around it, move it, do something. But what the court said, what the court inferred was, it was essential to the job to move it outside. Those were the words of the court.
Well, it was certainly essential to move it someplace, was it not?
Not necessarily, Your Honor. And when you go to the Schenkel case...
Well, let me ask you this. I mean, the evidence was clear that preceding times when the building had been cleaned, furniture had been moved. It had never been moved outside before, but it had been moved in the hallway. So can't we presume that it was that in order to do an effective job that one had to remove furniture from the premises which were being cleaned?
No, Your Honor, we don't. And here is why. The testimony was of Ms. Williams in the case. She said that it had not been done in the past where they had taken it out, and she said that she believed it had been moved around inside the building before. But the simple fact is that Child Time could have moved the furniture. And the simple fact is that the hallways that don't have furniture can certainly be cleaned. So when you go to what is the core element, and Ms. Baytop, testifying on behalf of Colony, admitted that the core purpose of the work, the main purpose of the work, was not moving furniture. So the fact that there is furniture present is merely an incidence to doing the work.
So it wouldn't make any difference whether the furniture was moved in the hallway or outside if the furniture were damaged in any way during its movement. You say that the exclusionary clause has no effect.
That is correct, Your Honor. That is correct. The work is being done on the floors, and that is the element that the work is being performed on. One of the cases, Your Honor, that we cited to the court early on was the Miser decision from Wisconsin. It talks about the essential work being done. That case involved where they were putting in drywall and plaster, and as part of the normal job, the contractor would go in and clean the windows because it would get plaster on the windows. And the court there said, your essential work is putting in drywall and plaster. The fact that you damaged these windows in the course of doing that work and had to clean it up does not put those windows in your care, custody, and control. And that's the real test that we're asking the court to apply here. Because whether the property is in the care, custody, control, Your Honor, is a factual question. That's what the Schenkel case said. And this issue of necessity, and again, there is no evidence, absolutely no evidence that you must move the furniture outside or that it even has to be moved to clean the floors. Furniture that is heavy could be cleaned up against. Furniture that's in an area that looks clean or is only covering a small area could be cleaned right up against it. So there is no evidence that is in this record that says you must move furniture in order to clean the floors. The court inferred that without any evidence and inferred it against Child Time when it should have been making inferences in favor of Child Time.
Let me ask you this then. Would there be leaving that aside for a moment, if they had damaged the furniture in the act of transporting it either to the other side of the room or outdoors, would that make a difference in terms of this exclusion than the way the damage occurred in this case, which I think was it rain or water? Or?
Yes, Your Honor, it had been taken outside.
If they were hauling the furniture off on some lowboys or something and the furniture got broken, would that be different? Would you have the exclusion there?
No, Your Honor, because the work that they were hired to do, the essential work, was to clean the floors. Any damage to any other property that occurs while they're doing the work is not covered by the exclusion. The only part that could be said to be put in their care, custody, and control would be the floors. If the buffer went bad and scarred the floor up, if they used too strong of a solvent and harmed the floors, that would be property in their care, custody, and control. That would be something like the reactor head. This is what you're working on. So it's in the care, custody, and control.
Hypothetically, suppose that there was a contract that required them to remove the furniture and replace it before and after cleaning. Would you then have something that was arguably in the care, custody, and control?
I think at that point you would, Your Honor. The reason is that it then becomes an essential part of the work. We have agreed that you will move the furniture.
So that's the fact question here that you say should go to a jury. Was the movement of the furniture essential to the job?
Yes, Your Honor.
And that there's a dispute of fact, and that issue alone requires reversal.
Absolutely, Your Honor. And in the footnote of our initial brief, we pointed out the one deposition that we've not been able to take. The Pep Boys case, Your Honor, clearly sets that out. Necessity of taking certain actions and performing a job is a question of fact for the jury.
Well, let me ask you, does Ms. Williams, who was the former director of the Child Care Center, she testified that she had expected the workers to move the furniture to the hallways because that is what they had been done by previous cleaners. Now, if that's the case, does that create a fairly strong inference that that movement was essential? The movement of the furniture was essential to the purpose of the job, which was to clean the premises.
No, because, Your Honor, we would also expect that they would turn on the lights in the rooms that they need to work in if they're off. We would expect that they would turn those lights back off. We would expect that they would be doing what other incidental items are part of getting their essential work done. And that is the key point. We would encourage the court to follow Chief Judge Sturgis in looking to the courts of other jurisdictions, those decisions in the Michigan Mutual case, where he found that the exclusion did not apply in that case because there was no exclusive control over the equipment that was damaged. Here, there was clearly no exclusive control over the furniture because we know that, according to the testimony, when they saw it, Child Time immediately took the furniture back inside. I reserve the balance of my time for rebuttal. Thank you.
Good afternoon. Hinda Klein here on behalf of the Appellee Colony. Opposing counsels primarily relied on his third argument in the brief, which is the incidental versus inherent distinction that's been made by courts in other states but has never been made by a court in this state. As we pointed out, there is no Florida law which has considered whether or not a particular property was incidental to the job in construing this particular clause. But in addition to that, as we argued, you cannot clean floors without moving the furniture, or at least clean them well.
But before you get into that, Ms. Klein, can you help me in my own personal difficulty that I have with in a correct construction of this clause? What is the purpose of an exclusionary clause as this? What is the insurer trying to do?
The insurer is trying to guard against the risk of collusion between, in this case, the insured and the plaintiff in making a claim under the policy for what is basically negligence in the performance of the insured's work. The point is not to make the insurance company a guarantor of the quality of the insured's work.
Does a clause like this apply to a situation in which Steamway was the actual owner of the personal property?
Steamway was not the owner of the personal
I know,
property.
but would it apply?
Well, then it wouldn't be a claim under the liability portion of the policy. The claim was made under the liability portion of the policy. It wasn't a first-party homeowner's case.
So it'd have to be only then through, if another person was involved. In other words, such as
Child
care. All right, okay, so a clause like this is simply attempting to reduce the opportunity of collusion or fraud vis-a-vis a third party and its insured.
That's part of it. The other part of it is it's not meant to be a warranty in situations where the insured does poor workmanship. And that was the evolution of the care, custody, and control exclusion. But what was really argued in the brief, and today I'm hearing a different argument from opposing counsel, is that, well, Steamway was not authorized to move the furniture outdoors, and therefore it was its negligence in moving the furniture out of doors that goes to the issue of control. Here today I'm hearing for the first time that it was moving the furniture at all, which raises the issue of fact in this case. But I've just reviewed the briefs, and I don't see any argument that was raised at the trial court level or in the briefs on the issue of there being a genuine issue of material fact as to whether it was necessary to move the furniture in the first place. And as the court has pointed out, the testimony that is in the record establishes that it had been moved before, and that that Child Time assumed that it was going to be moved again, and that their basic problem here was the fact of where it was moved as opposed to the fact that it was moved at all. But in any event, there is no law in the state of Florida that makes a distinction as to whether or not the control over the property was incidental or inherent in the work, and therefore we don't believe that that's dispositive of the issue here today. If the court has no further questions, I'll rely on my briefs. Thank you.
Thank you.
Your Honors, in response, Judge Irwin, you had asked about the purpose of the exclusion. In the petroleum industries case, which is a Louisiana case from 1982, in that case, Your Honor, the Louisiana appellate court looked at this exclusion and specifically said it's ambiguous under the circumstances because of the different natures involved, and it sets forth that public policy that's behind the exclusion. And as you pointed out, what it says in there is that the rationale doesn't support applying this exclusion to property that belongs solely and unconditionally to others. That's the rationale. That's the policy behind it. And in this case, where the property is solely and unconditionally that of Child Time, it makes no sense to apply this exclusion, because we're not talking about the quality of the cleaning job. They did a fine job cleaning the floors. We're talking about what they did incidental to that work, which was moving the property outside. And here is where we get to that issue of exclusivity. And in response to the argument that whether or not it should have been moved at all was raised, we would point out that at the hearing, we were precluded and stopped by the trial court from arguing whether or not it was reasonable as what they did. So that was where the argument was going on that. It was raised, it was shut down, we were denied the opportunity to bring that argument. But if you look at the International Derrick case, and there they talked about the incidental nature of the property. The court there looked at the Spire case. They focused on whether the insured had sole control over the property.
But again, the incidental issue goes to whether or not it was necessary to move the furniture in order to do the cleaning job. It seems to me it's hard to say that it's incidental if moving the furniture if the cleaning could not have been accomplished without moving the furniture.
Furniture only has to be moved in floor cleaning if it's actually present. You have to step back away from each individual circumstance, and I see my time is up if I could complete the answer there. You have to step away, and this is what the court talks about when in Schenkel, where it says you have to look at the nature of property. What are they doing with it? All of these circumstances. You have to step away from these specific facts and say, what did they agree to do? Clean the floors. You can clean floors without moving furniture. You only have to move the furniture in the incidents that it's actually present in those rooms, in those areas. So it's in that incidence of furniture being present that you have to move it. Therefore, the argument is it is necessarily incidental to accomplishing the work.
Thank you.
Thank you.